Today, in the media conference with Lal Goyal, which is brought to you by V4 News, Karu News, V4 Stream, Malnadu TV India, News Gaon se, Samvad Sarokar News, Bharat Post News, Gyan and Organ Donation India Foundation. Our endeavor is to enlighten you with the current topic. And today's topic is not only current, very controversial and very hot. And the topic is Njac versus Collegium. But before I will go on the main topic, I would like to inform you that today the world is celebrating International Mountain Day. December 11th is the International Mountain Day, was designated by the United Nations General Assembly in 2003. The General Assembly encouraged the international community to organize events at all levels on that day to highlight the importance of sustainable mountain development. International Mountain Day is observed every year with a different theme relevant to sustainable mountain development. FAO is the UN organization mandated to lead observance of International Mountain Day. Women Move Mountains is the suggested theme for 2022. The world's most spectacular landscapes are facing threats in every way. Climate change and global warming, bad farming practices, logging, commercial mincing, and poaching are taking a heavy toll on mountain biodiversity. Plastic pollution is also threatening the fragile environment. Sustainable management of mountain biodiversity has been increasingly recognized as a global priority. Media conference with Lal Goyal hopes that better sense will prevail and people will take care of mountains. Now coming to our main topic, Njac versus Collegium. The National Judicial Appointments Commission, Njac, was a proposed body which would have been responsible for the recruitment, appointment and transfer of judicial officers, legal officers and legal employees under the Government of India and in all state governments of India. The commission was established by amending the Constitution of India through the 99th Constitution Amendment with the Constitution. 99th Constitutional Amendment Act 2014 passed by the Lok Sabha on 13th August 2014 and by the Rajya Sabha on 14th August 2014. The Njac would have replaced the collegium system for the appointment of judges as invoked by the Supreme Court via judicial fiat by a new system. Along with the Constitution Amendment Act, the National Judicial Appointments Commission Act 2014 was also passed by the Parliament of India to regulate the functions of the National Judicial Appointments Commission. The Njac Bill and the Constitutional Amendment Bill was ratified by 16 of the state legislatures in India and subsequently assented by the President of India, Pranab Mukherjee, on 31st December 2014. The Njac Act and the Constitutional Amendment Act came into force from 13th April 2015. On 16th October 2015, the Constitution Bench of Supreme Court by 4-1 majority upheld the collegium system and struck down the Njac as unconstitutional after hearing the petitions filed by several persons and bodies with Supreme Court Advocates on Record Association, SCAORA, being the first and lead petitioner. A new article 124A, has been inserted into the Constitution. As per the amended provision of the Constitution, the Commission would have consisted of the following 6 persons: Chief Justice of India, Chairperson, ex officio; 2 other of senior judges of the Supreme Court next to the Chief Justice of India, ex officio; 2 eminent persons would have been nominated by a committee consisting of Chief Justice of India, Prime Minister of India and Leader of Opposition in the Lok Sabha, the Union Minister of Law and Justice ex officio. The Indian Judicial Collegium system, where existing judges appoint judges to the nation's constitutional courts, has its genesis in and continued basis resting on 3 of its own judgments made by Supreme Court judges, which are collectively known as the 3 judges cases. Over the course of the 3 cases, the court evolved the principle of judicial independence to mean that no other branch of the state, including the legislature and the executive, would have any say in the appointment of judges. The court then created the collegium system, which has been in use since the judgment in the second judge case was issued in 1993. There is no mention of the collegium either in the original Constitution of India or in successive amendments. The third judge's case of 1998 is not a case, but an opinion delivered by Supreme Court of India responding to a question of law regarding the collegium system. Justice Saxena, please mute yourself.
Okay.
The third judge's case of 1998 is not a case, but an opinion delivered by the Supreme Court of India responding to a question of law regarding the collegium system raised by then President of India, Sri K.R. Narayanan, in July 1998 under his constitutional powers. To discuss this very, very important, controversial, hot topic today, NJAC versus Collegium, we have a very elite, I will say, legal luminaries panelists are with us. And I would like to invite my first guest of panelist today, and he is Honorable Justice Mr. Rajiv Lochan Mehrotra. Honorable Justice Mr. Rajiv Lochan Mehrotra is the former Allahabad High Court judge. He is the chairman of Review Committee, which looks after Prevention of Unauthorized Activities Act. He joined service as civil judge. He worked as district judge at Bijnor and Agra. He also worked as judicial member State Administrative Tribunal. Welcome, Honorable Justice Mr. Rajiv Lochan Mehrotra on our show. But before I will take your views, I would like to take the views of and the opinions of our viewers who have sent their opinion. And the first opinion is from Mr. M.S. Srinivasan IAS. He is the former Secretary, Ministry of Petroleum and Natural Gas, Government of India. He is of 1970 IAS batch. And his views are the whole collegium process is a mysterious puzzle shrouded in an enigma and clothed in secrecy, followed by holier than thou persons who consider themselves descendant from heaven. This myth has to be blown and more openness warranted. Judiciary is also a part of the national governance and should not consider itself to be above all. I support NJAC. These are the views were the views of Mr. M.S. Srinivasan IAS. He is the former Secretary, Ministry of Petroleum and Natural Gas, Government of India, IAS 1971 batch. One more view we have received, and that view is of Advocate Ramesh Kumar Sharma. Advocate Ramesh Kumar Sharma is a leading lawyer of Western UP with more than 43 years of practice. And his views are NJAC Act was not a good law. Its language was defective. It was amounting to interference in freedom of judiciary. That's why it was struck down by Supreme Court. A new act may be passed correcting the mistakes. No one can stop Parliament in passing new laws. The present collegium system is unable to produce the required quantity of good judges. Most of the appointments are judges' family or chamber, which shows Bhai Bhatijawad. It also required a drastic change. The actual talent is not being elevated in good quantity. These are the views of Advocate Ramesh Kumar Sharma, who is a leading lawyer of Western UP with more than 43 years of practice. Now, Honorable Justice Mehrotra, you have heard the views of two of our viewers, very, very strong views. And you have also, you know that very well about the NJSC versus Collegium. And it's become a very, very hot topic nowadays. Every day we are listening the views of from the ruling party, even law minister, or even the Vice President of India. He has also spoken. And we are also listening what is happening in Supreme Court, where the Honorable Supreme Court, one of the bench is also talking about this system. We would like to know from you your views on NJC versus Collegium. Honorable Justice Mr. Rajiv Lochan Mehrotra, please.
थैंक यू सो मच। नमस्कार साहब, सभी को नमस्कार। बहुत सेंसिटिव टॉपिक है एनजेसी वर्सेस कॉलेजियम सिस्टम। कॉन्स्टिट्यूशन ने इंडिपेंडेंस दी है जुडिशरी को, और कॉन्स्टिट्यूएंट असेंबली ने शायद लेजिस्लेटिव से इसको अलग रखने के लिए प्रेसिडेंट को ये पावर दी थी कि आफ्टर कंसल्टेशन विद द चीफ जस्टिस ऑफ इंडिया वो अपॉइंट करेंगे जजेस को। लेकिन उसके बाद जैसा कि अभी चर्चा में आपने बताया, सुप्रीम कोर्ट को ये पसंद नहीं था। 1981 में ये कहा गया कि कंसल्टेशन मींस कंकरेंस, कंकरेंस मींस कि legislation executive may or may not agree with the opinion of the Supreme Court Justice of India। तो उन्होंने कहा कि नहीं, ये इट इज रॉन्ग। और फिर उसके बाद उन्होंने कहा कि इट शुड प्रिवेल। 1993 में जजमेंट में उन्होंने कहा सुप्रीम कोर्ट ने कि ओपिनियन ऑफ द चीफ जस्टिस ऑफ इंडिया एंड सुप्रीम कोर्ट शुड प्रिवेल ओवर द एग्जीक्यूटिव। अगर जजेस को एलिवेट करना है, अपॉइंट करना है, तो हमारी ही ओपिनियन प्रिवेल करेगी। और उसके बाद 1998 में, जैसा सभी को पता है, एक नया सिस्टम इवॉल्व हो गया, और कॉलेजियम सिस्टम में उन्होंने कहा कि साहब हाई कोर्ट जजेस के एलिवेशन के लिए स्टेट हाई कोर्ट के चीफ जस्टिस प्लस 2 सीनियर मोस्ट जजेस वो रिकमेंड करेंगे, और सुप्रीम कोर्ट के लिए चीफ जस्टिस ऑफ इंडिया प्लस 4 सीनियर मोस्ट जजेस वो एलिवेट करेंगे। और उन्होंने उसमें साथ में एक ये भी तय कर दिया कि अगर हम रिकमेंड करते हैं और आप अगर उसको ऑनर नहीं करते हैं, तो सेकंड टाइम जो हमारा वो रिकमेंडेशन होगा दैट शैल बी बाइंडिंग ऑन द एग्जीक्यूटिव। या अब उसके बाद ये सच है कि शायद इट इज द ओनली सिस्टम इन द वर्ल्ड जहां पे जजेस को चुन रहे हैं। किसी और कंट्री में ऐसा हमने सुना नहीं। और जैसा एक व्यूअर ने अभी हमारे बताया है, आज हम पॉलिटिक्स में एक वंशवाद की बात कर रहे हैं। डिफरेंट पॉलिटिकल पार्टीज को लेके हम कहते हैं साथ कि वो उनके यहाँ ही उनके बच्चे और नेक्स्ट जनरेशन आ रही। आई विल नॉट नेम द मैन जो एज ए चीफ मिनिस्टर जिन्होंने वर्क किया है, लेकिन उन्होंने एक बार कहा था कि जैसा हमारे यहाँ तो हर 5 साल बाद इम्तहान होता है। ये ठीक है कि हमारे फादर या हमारे फोर फादर भी अगर कहीं पॉलिटिकल लीडर थे, और तो उसके बाद अगर हमको इनहेरिट हमने किया है, तो हम इलेक्शन लड़के और पब्लिक का मैंडेट पाने के बाद यहाँ तक पहुँचते हैं। आपके यहाँ तो जो 2 लोग 3 लोग रिकमेंड कर देते हैं, फिर 62 ईयर्स तक या 65 ईयर्स तक फिर आपकी तो कुर्सी पक्की हो जाती है, आपको कहीं कुछ नहीं करना है। तो ये सच है कि हमारे यहाँ जो सिस्टम इवॉल्व हुआ है, इसने हम इसको बहुत ज्यादा कहना नहीं चाहेंगे, लेकिन ये व्यूअर्स पे छोड़ते हैं कि 1993 के पहले के जो जजेस थे उनको और उसके बाद के जजेस को व्यूअर्स कैन कंपेयर इट। हम उसमें कुछ हमको उनके विषय में कहना नहीं। लेकिन अब एनजेसी लाने के बाद, एनजेसी जिस फॉर्म में आई थी, उन्होंने कह दिया कि साहब उसमें 3 चीफ जस्टिस ऑफ इंडिया, 2 सीनियर मोस्ट जजेस और लॉ मिनिस्टर एक्स ऑफिशियो एंड 2 मेंबर्स ऑफ द सिविल सोसाइटी। अब अच्छा, और उसमें एक प्रोविजन था कि अगर 2 मेंबर्स भी उसमें किसी नाम पे डिस्प्यूट करेंगे तो फिर वो एलिवेट नहीं होगा। तो ये माना गया कि ये इनडायरेक्टली सिस्टम में इंटरफेरेंस हो गया। इस सिविल सोसाइटी के मेंबर्स अगर मान लीजिए प्रो गवर्नमेंट है, जो भी गवर्नमेंट है, तो वो अगर कुछ भी कह देंगे तो लॉ मिनिस्टर पास कहने को जाएगा, साहब ये 2 मेंबर्स जो अपोज कर रहे हैं इसलिए इनको हम एलिवेट नहीं करेंगे। तो वो भी सिस्टम बहुत अच्छा नहीं था, इट नीड्स रिफॉर्म। लेकिन कॉलेजियम सिस्टम के विषय में हम इतने कह सकते हैं कि आज वी आर गेटिंग सैलरी एंड पर्क्स फ्रॉम द पब्लिक एक्सचेकर। जनता के पैसे से हम सैलरी ले रहे हैं, सभी लोग सारी सुविधाएं ले रहे हैं, और एलिवेशन के लिए देयर शुड बी सम सॉर्ट ऑफ टेस्ट इन द सेंस कि वो क्वालिटी कैसे एसेस करेंगे। हम जिनको एलिवेट कर रहे हैं उसके विषय में जरूर कुछ एक ऐसा सिस्टम बनाया जाए जिससे हम देखें कि जो लोग एलिवेट होंगे क्या वो इस लायक हैं कि नहीं। आज पूरा हिंदुस्तान परेशान है पेंडेंसी को लेके, डिस्पोजल को लेके, नंबर ऑफ केसेस तेजी से बढ़ रहे हैं। शायद ये कहीं पे हमारे सिस्टम का फेल्योर है। नंबर ऑफ जजेस बढ़ाने से कुछ नहीं होगा, लेकिन अगर जजेस तेज हैं, जजेस जीनियस हैं, जजेस का डिस्पोजल फास्ट है, तो बहुत से केसेस को हम तेजी से डिस्पोज ऑफ कर सकते हैं। तो ये सिस्टम जो है ये ठीक है कि इंटरफेरेंस एग्जीक्यूटिव पर नहीं होना चाहिए, वरना हमारा जो इंडिपेंडेंस है जुडिशरी की पूरी तरह खत्म हो जाएगी। लेकिन साथ में कुछ ऐसे लोगों को इंक्लूड भी करना चाहिए इसमें, अपार्ट फ्रॉम 2 जजेस एंड चीफ जस्टिस ऑफ इंडिया, जिससे कि ये पता लग सके कि आखिरकार उन लोगों की जिनको हम एलिवेट करने जा रहे हैं उनका आईक्यू क्या है, उनकी एबिलिटी क्या है, और उनका पास्ट कैसा रहा है। यहाँ पे थोड़ी सी शिकायत हमको गवर्नमेंट एजेंसीज से भी है। जितने लोगों का नाम रिकमेंड होता है एलिवेशन के लिए फ्रॉम द सर्विस और फ्रॉम द बार, गवर्नमेंट को उनके विषय में पूरी जानकारी करने के लिए आईबी की रिपोर्ट और एलआईयू की रिपोर्ट भी आती है। लेकिन ऐसा लगता है कि शायद ये केवल एक फॉर्मेलिटी, एक मियर फॉर्मेलिटी रह गई है, क्योंकि हमने बहुत से बाद में ऐसे लोगों को एलिवेट होते देखा है जिनके विषय में अब तो काफी कुछ चर्चाओं में आ रहा है, चर्चा हुई है और लोगों ने जानकारी की है। तो वो कहीं पे फेल्योर गवर्नमेंट का भी है कि उन्होंने आईबी की रिपोर्ट ठीक से नहीं की या रिपोर्ट्स नहीं ली। तो हम नेक्स्ट राउंड में और अपने पैनलिस्ट को सुनना चाहेंगे। लेकिन ये सच है कि अकेला कॉलेजियम सिस्टम इस पूरे सिस्टम को संभाल नहीं सकता, उसमें कुछ और लोगों का इंक्लूजन होना चाहिए, इसमें और थोड़ा सा अमेंडमेंट होना चाहिए, लेकिन ये पूरा पूरा एग्जीक्यूटिव के हाथ में नहीं जाना चाहिए, वरना फिर वो अमेरिकन स्टाइल में गवर्नमेंट की जुडिशरी हो जाएगी और कोई पर्पज इसका नहीं होगा। थैंक यू सो मच।
Thank you very much, Honorable Justice Mr. Rajiv Lochan Mehrotra, for giving your views. And I will just point out 2 things. One thing is Honorable Justice Mehrotra mentioned that as per the collegium system, once the recommendation goes to the government and if they return some names, and if the second time it goes, automatically the government has no other choice but they have to accept. But recently, we have seen, very recently, that some names have come back. Whether it will be termed as a contempt of Supreme Court or not. And if yes, then who is going to be the party? We will check up with him the next time. Secondly, he mentioned about the report, IB report and the LIU report. If a person who is going to be elevated from the Chief Justice of a particular High Court to the Supreme Court, if his reports are not good at that time, why he was continued till that time as a Chief Justice? That is also one of the reservation, because today if suppose somebody is a High Court judge and his record is not good, after all IB and LIU are working 24/7, so if they cannot point out to the government that this justice is having some dubious record in this year, then why action was not taken at the time of elevation only we are doing it. So this also we will clarify next round. Thank you very much, Honorable Justice Mr. Rajiv Lochan Mehrotra, for giving your very, very frank views, because you yourself being a High Court judge, you know the system very well from inside, and you know the working of the government as well as the Honorable Supreme Court. Thank you very much. Now, I would like to invite my next panelist guest, and he is Honorable Mr. Justice Sudhir Kumar Saxena. Honorable Justice Mr. Sudhir Kumar Saxena is the former High Court judge. He was graduated in law in 1976. Honorable Justice Saxena registered with Bar Council of UP in year 1976. He practiced in Allahabad High Court on civil, constitutional, and criminal side for more than 17 years. He represented various banks, local bodies, and development authorities. He was standing counsel for state of UP from 1990 to 1994. Honorable Justice Mr. Saxena held office in bar associations. He was appointed in higher judicial service on May 12, 1994. He was promoted as district and session judge on November 28, 2006. He was elevated as additional judge on September 5th, 2011. He took oath as permanent judge on August 6, 2013. He worked as chairman of Magistrate Court, monitoring controller, member of Juvenile Justice Committee, High Court and Legal Aid Committee, Lucknow Bench. He was appointed as chairman of UP Public Service Tribunal on 1st February 2017. He retired on 31st January 2022. He was designated senior advocate by Supreme Court of India on 20th May 2022. Welcome, Honorable Justice Mr. Sudhir Saxena. Honorable Justice Saxena, before I will take your views, I would like to take the opinion of our viewers who have sent their opinion. And first opinion is from Mr. Bhupati Prasad Pandey, IAS. He is the former Additional Chief Secretary, Government of Maharashtra, and he's of 1976 batch of IAS. And his views are, Supreme Court can ask government for papers relating to an executive decision. Why can itself not make available collegium papers on basis of which president makes appointment to courts? This arbitrariness can survive in a democracy? Question mark. NJAC pending since nearly a decade. Why object to an objective selection just to continue? You scratch my back, I scratch you later. And then he has sent in a Hindi. I don't know whether it is his or some forward, but I will just read it. And I cannot vouch for the facts, whether these are correct or not. These are the views sent by the retired IAS officer, Mr. Pandey. And this says, Hindi mein hai, 1979 में Y चंद्रचूड़ ने बीएन कृपाल को जज बनाया. 2000 में बीएन कृपाल ने वाई चंद्रचूड़ के बेटे डीवाई चंद्रचूड़ को जज बनाकर अपना पुराना कर्ज उतारा. अब डीवाई चंद्रचूड़ ने बीएन कृपाल के बेटे सौरव कृपाल का नाम जज के लिए भेजा है, ताकि बीएन कृपाल ने जो 2000 में उसे जज बनाने के लिए नाम भेजा था, वो कर्ज उतारा जा सके. अब भारत को ईमानदार, पारदर्शी, न्यायिक कॉलेजियम व्यवस्था से सौरव कृपाल को आज या कल जज बना ही देंगे. 4 साल से कोशिश की जा रही है. फिर 2034 में सौरव कृपाल डीवाई चंद्रचूड़ के बेटे का नाम जज के लिए भेजकर अपना कर्ज चुकाएंगे. और इसी तरह से कुछ परिवारों के बीच में ये हाई कोर्ट और सुप्रीम कोर्ट के जज बनने की कॉलेजियम प्रक्रिया चलती रहेगी. किसी दूसरे को मौका मिलने से रहा. हाई कोर्ट और सुप्रीम कोर्ट की पावर कुछ परिवारों के मुट्ठी में कैद है. These are the views of Mr. Bhupati Prasad Pandey, IAS. He is the former Additional Chief Secretary, Government of Maharashtra, and is of 1976 IAS batch. One more view has come, and it has come from Mr. Deepan Shah. Mr. Deepan Shah is an Asian Indian ambassador for organ and tissue donation awareness of NJ Sharing Network, New Jersey, USA. And his views are, does not matter though by NJAC or Collegium, as long as clarity of mind, clear vision, responsible towards society, and commitment of giving due diligence, responsibility is matters. In US, judges are appointed by president and confirmed by Senate. Indian system, weak communications, channels, and obligations of political appointments. As we Indian understand our thousands of years of history and heritage, but when implementation comes, we look for profit rather than responsibility. These are the views of Mr. Deepan Shah. He is Asian Indian Ambassador for Organ and Tissue Donation Awareness of NJ Sharing Network, New Jersey, USA. Welcome, Honorable Mr. Justice Sudhir Kumar Saxena on our show. Justice Saxena, can you just turn your mobile in a horizontal position? Yes, please. And unmute yourself. Honorable Justice Saxena, you have heard earlier panelist, Honorable Justice Mehrotra, as well as the views of our viewers. Very, very strong views. I already read 4 views. We would like to know now from you, your views on very, very controversial, but very, very important topic, that is NJAC versus Collegium. Honorable Justice Mr. Sudhir Kumar Saxena.
Good morning, Mr. Goel and the viewers. You have landed us in a difficult position because question is equally difficult. In one word, it cannot be said which is better. Now I'll give some examples. We had Justice Karnan, and then we had 2 more judges who are facing CBI inquiry, and their impeachment was recommended by the government, Chief Justice of India, successive justice, and nothing was done in that matter. And Judge was able to complete his tenure fully. We know another Supreme Court judge who immediately before completing term resigned and joined one of the regulatory body. And we know another judge who insisted on his brother's elevation and now enjoying another office. We also know recently that one of the judge, I will not say, he gave a controversial judgment and he was given a plum position. This is the case of, these are the judges appointed by the Collegium. Now we know the judges which were appointed by the executive, A&A and Justice Bhagwati, they also proceeded, we all know it. But we also had the judges like Krishna Iyer, Wangchu, H.R. Khanna, they were appointed by the executive. So it is difficult to say that executive will appoint always dishonest judges or judges with disputed doubtful integrity, and Collegium will give always the best judges. Now, independence has no nexus with the appointment. The NJC was set at not on the ground that it will erode the independence of judiciary, which is a basic structure. We know there was a problem for secretariat. Now there's no accountability of judges. Whatever you do, no mechanism for dealing with the complaints, no secretariat, no complaint forum for examining the complaints, and then post-retirement assignments, they are very lucrative, and just Jetli had said that people give pre-retirement judgment for post-retirement assignments. There's no cooling off period. In these circumstances, the executive, I mean, it's well known that executive is prone to control all the regulatory bodies. In these circumstances, and we have to tread with caution and save the judiciary, which is the only safeguard. Now, India is a diverse country, and there are electoral compulsions. Can we conceive a political party ruling this central government, having number of partners, and if everything is left in their hands, they will fight for their share of law. One judge from one from my side, one from another party. It will be difficult. And the second question is, how will they assess the capability or integrity of the advocates? Here, 67% are elevated from the bar, 33% or from service. I may here point out that the service judges have earned repute and respect in Parliament, it has been said. But unfortunately, their quota is 33%, sometimes is not filled even. And their tenure is so short that they are not able to participate in the administration. It's different aspect. I will recommend that should be raised at least up to 50%. But then this doesn't matter. Judges, lawyers appear before the judges every day. Therefore, they know about their competence, capability, and also because by the grace of the period, they considered it is only 20-25 years period. Then they know that this lawyer is honest and capable and is sincere, competent, and will and pro-constitution. He believes in constitutional values. So therefore, they are in a better position. Therefore, the selection part should remain with the Supreme Court or the High Court judges. Of course, executive must say very well women are less represented, or the other sector of society are less represented, or that only, as rightly said, you scratch my back, the only people from coterie are being considered. So that fault is that flaw is there with the collegium system. So for that, NJC was good, but then it also suffered from the same thing. If we have to check this, we have to increase, we have to broad-based consideration should be there. And for this, people from other sectors of the society, not only from the particular families. Here, I may point out, I may caveat that lawyers can become lawyer, politicians become politician, doctors can become doctor. There's no difficulty in judges can become in practicing and ultimately being considered for the elevation, because they know the system from the day one, from their birth. They are seeing the clients, litigants, and the discussion going on in the house. So, but then they alone should not be considered, and therefore, and the criticism that you stress my basket is absolutely well founded. I don't dispute this, but all this cannot be checked by merely giving entire power to the executive. In India, when we compare it with the America or other different countries, here moral is problem. Indian politicians, as we said, they always think about the elections. Now MCD election, then Gujarat election, the Andhra election, Karnataka election, then Parliament election. So they will not. We cannot take guarantee that they will always take a moral decision. In other countries, this problem is not there. Therefore, we have trusted the Senate or the Congress. Here, we have seen how bills are passed. Now, some names are floated in the Parliament, and immediately they are passed. Nobody will have say, or they will compromise. We have seen so far as Human Rights Commission is concerned, of other bodies where leader of opposition is a party, how appointments are made. We have seen this. So they compromise, chairman mine and members yours. So that we have to ensure, we have to insulate the executive from the judiciary. Now, earlier, I remember in Allahabad High Court, we did not allow Prime Minister to enter the High Court. Now judges are feeling honored in sharing dais with the politician, minister, Prime Minister, and the other state ministers. This should not be done. There should be a distance between executive and judiciary in order to keep its integrity intact, which is not happening. I suggest that Supreme selection part should remain with the Supreme Court and Supreme Court or the High Court, because they know the people, and inputs from the government should be taken, and both should sit together and should finalize the best names. The collegium system, NJC system, which provided for 2 eminent persons, was again left with the hand of 3 persons. They will select persons. Now we know what is happening with the NGOs, how civil societies are working. So they cannot be trusted if we want foolproof judiciary, independent judiciary, because in these circumstances, in these diverse circumstances, in the diverse country, independent judiciary is need of the hour, and it is too early to presume that this will promote them. People are there also listening to the voices, and of course transparency is needed, and they are up to some extent they have diverted to the transparency, but then some more efforts are needed. We cannot say that NJC was foolproof or the collegium was foolproof. Both have given good judges, both have given bad judges. I remember so far as IB reports are concerned, mostly collegium bases its decision upon the reports of the IB. In Allahabad High Court, IB had given a report against one justice judge. He was not selected. Then second time he was considered, he pulled some string, and he was considered, he was elevated. So reports are, even Justice Ramanna had said in function of the Bar Association that yes, this is like just IB reports. So they are manipulated, they are procured. This alone cannot be a basis. It should be broad-based inquiry, just a little more discreet as well as open inquiry about the candidate, because who are going to lay down the law. And at the moment, I suggest that some secretariat should be brought. A mechanism for dealing with complaints should be made. Quota of the service judges should be raised. And I would say if judge has more than 5 years period in a particular high court, he should be invariably transferred to other high court, so that this practice of the family coterie is taken care of. This is how I deal with this problem. Thank you, Mr. Goel.
Thank you very much, Honorable Justice Mr. Sudhir Saxena, for giving your views. And although he has given lots of views, but I will just highlight one or two. First thing he says, because nowadays the countries having the central government or state governments are having a mixed government with lots of partners. So he says, if it is going to be NJC, it will be definitely everyone wants the pounds of flesh. So the judges, everyone wants from their reason only or from their favorite only. That will be a difficult thing. Secondly, he mentioned about the IB reports, and he says it's a eyewash because sometimes the IB report says very against, and the next year the same judges was elevated. So how come it can be? Third, very important thing he mentioned is that earlier no one, including the Prime Minister, was allowed to enter in the High Court or the Supreme Court or share the dice with the judges, but nowadays it has become a common practice, and we have seen for last every time we are seeing that either they are sharing the dice with the Honorable Prime Minister or with the Law Minister or other ministers also many times. So according to him, unless we are morally clear, he says we cannot compare ourselves with the other country because our question is the moral here. So again, the same problem, but he says things are there, and he also says it's very, very difficult to decide who is going to be the correct thing. But according to him, still the collegium system is bit better than the NGAC. So this is his views. So thank you very much, Honorable Justice Mr. Sudhir Saxena, for giving your views. Now I would like to invite my next panelist guest, and he is Advocate K.C. Jain. Advocate K.C. Jain is a renowned social activist and Supreme Court lawyer. He is practicing law for last 42 years on the civil side. He has appeared in Supreme Court and Allahabad High Court in several important cases. He is active on various social platforms of the city of Agra. He filed several PILs in Supreme Court regarding the RTI Act, etc. Recently also he filed a petition relating to road safety. His large number of articles were published in law journals. His articles were also published in many newspapers on various subjects, including environment, RTI, culture, etc. He has varied interest, especially in RTI and environment. Welcome, Advocate K.C. Jain on our show. Advocate K.C. Jain, before I will take your views, I would like to read the opinion of our viewer, and the opinion says from the opinion is from Professor Dr. R.K. Arya. He is the Professor of International Economics at Manav Rachna International Institute of Research and Studies, Faridabad. And his opinion is the issue of NJAC generally comes up with BJP government in power. Minded viewers, I would like to tell you these are the opinion of our viewers, and we are in a democratic country. So I am not editing any of his opinion. So you have to, and this opinion has nothing to do with media conference with Lal Goyal or with any of our partner channels. So the issue of NJAC generally comes up with BJP government in power, while Collegium has been successfully working. Why should be the need of NJAC except it satisfies the ego of majority government? While other officials will be intermixed with pure jurists and system will develop flaw. And once other officials exercise their opinion in selection and posting, there would be a component of revenge or favor, which would send the bad message down the line. The command which goes down to lower courts sometimes can make them non-serious. Secondly, public and lawyers will see them being insulted. Since it is a collegium now means college of selecting and transferring judges by the senior most judges, whose selection is again through following the process based on pure merit and probity in public life. An element of favor or biasness has the minimum chance of being present in the selection. Once NJAC is formed, definitely the selection and appointment will have an unfair approach. Whole judiciary faith will be in doldrum. Secondly, when their organs of democracy are pure in themselves, why impurity in judiciary? Rather, executive instead exposing and diluting the position of judges should support them in providing financial support and also tone up the law colleges. Rather, retired judges should be made chancellors in these colleges. The moral is beaten down by the executives many times. The system becomes shabby when executive without any logic transgress in other fields when they have no knowledge about the subject. These were very, very strong views of Professor Dr. R.K. Arya. Is the Professor of International Economics at Manav Rachna International Institute of Research and Studies, Faridabad. Advocate K.C. Jain, you have heard our two prominent panelists, Honorable Justice Mehrotra and Honorable Justice Saxena. They have given their views. And you have also heard the views of our viewers. Now, you being in profession for last so many years, and you have seen so many judges, right from the district courts to the high courts to the Supreme Court, and you have come across all types of judges. We would like to know your views on today's topic, that is the NJC versus Collegium. Advocate K.C. Jain, please.
Thank you, Mr. Lal, for giving me this opportunity to share my views. I would say that the Collegium system is better than NJAC, but the Collegium system needs reforms, changes, better participatory role of the lawyers and other judges. Ultimately, we in our constitution have the separation of powers, the legislature, executive, and judiciary. The actions of the executive, the legislations passed by the legislatures, and legislations passed by the legislatures are being examined by the Supreme Court and the High Court in their jurisdiction under Article 226 and Article 32. Not only examining a legislation, they also very often examine the legality and constitutionality of the executive actions. Therefore, while this central pillar, namely the judiciary, is to examine the actions of the legislature and the executive, if the process of appointment of judges is by the executive or by the lawmakers, the policymakers, then how can we achieve the cherished goal of our constitution, of the founding fathers of our constitution, that we should have a separation of powers? Because mixing the powers with each other would not lead to a balance. Ultimately, that will intermingle the things. What politicians think may not be correct. What the wisdom of the elected representatives may not be in consonance with the principle of equality, may not be in consonance with the many other principles in the Constitution. Therefore, unless we have a system of an independent system of selection of judges, we cannot achieve this purpose and objective. Therefore, I believe that though this is a judge-made law, by which the collegium system came into existence, but the word consultation with the judge, with the court, with the judiciary, has been interpreted as concurrence, and rightly so. If the judges advise that particular person should be made as a judge, and the politician have the final say, then what is the advice? What is the that consultation process? Therefore, the consultation has been rightly interpreted and construed in the judgments of the Supreme Court as concurrence, and the primacy to such concurrence is the underlying idea of the judgments. As I say that this system also needs reforms. Now the Collegium of High Court is only of the 3 judges. In the Supreme Court, it is of the 5 judges. Why not more judges? Opinion is also sought for. The sitting judges, the retired judges, for a person whose candidature is considered for judgeship. If only the 3 judges are there, they may not arrive at that greater accuracy as compared to a greater involvement and participatory role of other judges as well. I would say that not only it is the judges' process, there should be a platform that the digital platform should be created. The court should evolve a process of inviting applications or other people recommending the name for judgeship. Let the feedback of the people, let the feedback of the members of the bar, let the feedback of the sitting judges and retired judges may be received. No, of course, that may not be come in a public domain, but feedback should be there. And based on those feedbacks, decision can be taken. Then it will not be confined to 3 judges in the High Court or the 5 judges in the Supreme Court. Thereby, a greater participatory role of the bar and bench would definitely reduce the shortcomings which we have witnessed or which people allege in the collegium system. What is the role of the government? The government has not, what is the budget which government gives to the judiciary? The budget is very less. We need to make better infrastructure for the judiciary. Now, what we are suffering from, you just see that the total strength of the subordinate judges, the district judiciary is 25,000 judges. We have around 20,000 or 19,000 judges at the moment. The vacancy is 20%. Who is to be blamed? The government wants to have the power of appointment, but where they have the power to appoint the judges, they are not appointing the subordinate judiciary. The promise to bring all India judicial service is pending for last long time, but the government has not taken a call. Government should take a call that we should have an all India judicial service. Let better stuff, better people from other states also come to our state, and our people go to other state. What about the reforms in the laws? We are waiting for the reforms in the Civil Procedure Code. We are waiting for the reforms in the Criminal Procedure Code, the Evidence Act, and many other acts, but they are not forthcoming. The legislative inaction and apathy in bringing laws and updating them is pinching to every litigant. The entire judicial world, and the justice dispensation system is heavily suffering. What the government should do, first of all, it should realize that it is to fund better in a better way, create more infrastructure, appoint more judges in the district judiciary. What about the vacancy in the high courts? High court is also responsible for not sending the names, but at the same time, the government is also responsible for sleeping over the names of the judges names have been recommended, even the names of the subordinate judiciary. Who is suffering? People at large are suffering. There are more than 4 crore cases are pending. People have lost their faith in the institutions for the delay, by reason of the delay, which frustrate the very purpose of bringing the litigation in the courts, whether in the subordinate courts or in the high courts. We are not thinking how to overhaul the system, how to improve the justice delivery system. We are fighting over the collegium system or this judicial appointment commission. We are fighting over these things, but we are not thinking how to reduce the backlog, how to have better judges, how to reform the laws. They make laws without debates. They don't take the laws to select committees, parliamentary committees, and the parliamentary they are taken to parliamentary committees. The recommendations are not always accepted. The lawmaking process, the government is to improve. Ultimately, why should there be ambiguities? Why the court should be given the task to interpret the law? Why can't we make the law very explicit, which can be followed and which can be implemented in true sense? All these things, these actions which the government have to take, the government is lagging behind. I don't say the judges are not also to be are not also to introspect. what Justice Saxena has rightly said, that there should be a platform for complaint, there should be secretariat, there should be in-house. They have said that there should be in-house inquiries. But what will happen? We need to change the law relating to appointment of judges also. Let the judges be appointed for a shorter period, and if their work is up to the mark, let that collegium again recommend their extension. It is not that we appoint a judge and he will remain for 14 years, because the impeachment process is very difficult and cumbersome. No, very less number. How many judges have been impeached? Not at all. 1 or 2 or 3, not more than that in the entire independent history of the independent country of India. Therefore, we need to appoint them only for 5 years, short-term appointments, then then examining their capabilities, their temperament, their competence, their integrity, and then recommending. Therefore, instead of the government fighting with the judiciary all the time, accusing each other, we need to have a better judicial system where the common man can get justice. Justice is becoming costlier every day. You have to pay heavy fee to the seniors. Senior charge money whether the case goes on or it doesn't go. You have to pay once it is called out. We have to make law bring the justice delivery system within the reach of a common man and common masses, so that we can see a society based on rule of justice, rule of law. Ultimately, justice has to be given to each and every person, and in the weakest person of the society. And that is possible by improving the judicial system. Unfortunately, the politicians consider the judiciary as their rivals instead of their helping hands. They should improve their lawmaking process. They should reform the laws. They should have more funds to for creation of infrastructure. They should have more judges. The judge population ratio, judge case ratio is very poor, and the laws are made in haste. Babus make the law instead of experts being associated with the lawmaking process. These all things need consideration. We should not fight with each other, but we should improve a system which delivers justice. This is how I perceive the issue. Instead of saying what is better, we need to deliver to the common man the justice. Thank you, Mr. Lal.
Thank you very much, Advocate Jain, for giving your views. 2 points which I would like to highlight because time is short. So one thing says about the poor infrastructure, the financial support. We have seen during the elections, all the powers goes to the Election Commission. And Election Commission, I have no paucity of funds. If Election Commission can have the funds available because for the elections, why not the Supreme Court should have the funds? All the money in the form of court fees which have been collected by the courts should be assigned directly to the courts, not to the government at all. Then only I think that infrastructure and the dependence on the government, as one of the earlier panelists mentioned, that the salary is coming from the government. No, it should not come from the government. Court is earning lots of money in the form of court fees, stamp fees, etc. They should get it. Otherwise, the government, even if they are paying, they should not think that they are paying that they are the donors. They are not the donors. They are under obligation to pay to the judiciary for the benefit of the democracy only. Secondly, he mentioned about that the examinations and the evaluation for the short term of the things. Yes, it is a very good suggestion. I think so, although I am not a legal person, but I feel that anybody should be evaluated time to time so that a person should know what is the capability and how he's going. Thank you very much, Advocate Jain, for giving your views. There are so many things, but I have to give the platform to others. Thank you very much. Now, I would like to invite my next panelist guest, and he is Advocate Dev Prakash Singh. Advocate Dev Prakash Singh is the advocate at Patna High Court. He is member in several government advisory bodies to study the monitoring and conducting of the service conditions of a large number of employees to the tune of more than 50,000 for mega corporates, MNCs, PSUs, and government bodies. He is member of Regional EPFO Committee, Bihar and Jharkhand. He is chairman of Labor Resource Subcommittee, Bihar Industries Association. He is president of Central Association of Private Securities Industries, Bihar Chapter. His articles are published in several prestigious magazines. He is the author of Labor Law Support LLS, published by Bihar Industries Association, which was released by former President of India, late Shri Pranab Mukherjee. Welcome, Advocate DP Singh, on our show. But before I will take your views, I would like to read the view of opinion of one of our viewer, and she is Miss Hemlata, former airport manager, Chennai. According to Miss Hemlata, in NJAC, the involvement of government council is more, and 1/3 could be constitutionally and blissfully unaware of the Supreme Court and decide the destiny of higher judiciary. The Collegium and the judiciary will set in motion a subversive influence of our own design that destroys us from within because of dilatory, arbitrary, and smeared by favorites and the present collegiate elitism in the vanishing point of democratic values in the justice pyramid. These are the views of Ms. Hemlata, former airport manager, Chennai. And we also have one more view, which has come from Advocate Shashank Dev Sudhi. He is practicing in Supreme Court, New Delhi, and various high courts of the country for over 20 years. And his views are, I am of opinion that legislature is the fountain of all acts of the democracy, and judiciary is to act as checks and balances over other organs of the state. And if judiciary start legislating, then who will guide the guardians? Thus, I firmly believe that judiciary should not take legislative responsibility, which is in the domain of parliament only. These are the views of Advocate Shashank Dev Sudhi, who is practicing in Supreme Court, New Delhi, and various high courts of the country for over 20 years. Welcome, Advocate DP Singh, on our show. Advocate DP Singh, you have already heard two Honorable Justice Mehrotra as well as Justice Saxena of their views, as well as Advocate KC Jain. And you have also heard the views of our viewers, very, very strong views. We would like to know now from you, your views on this very, very important and controversial topic, and that is NJAC versus Collegium. Advocate DP Singh, please.
Good morning, Goel Sahab, and very good morning to the other panelists. Though I think the three panelists, Mr. Jain Sahab and Justice Lochan Sahab and Justice Sudhir Saxena Sahab, I think they might have engaged in their morning breakfast. That's why they have off their visibility from the video system. Only Mr. Gagan Gandhi, who is to speak, is available here. Saxena Sahab has come over. Thank you, sir. Dosan Mehrotra Sahab also come. Jain Sahab, I have seen that his wife has come with the breakfast bowl, so he might be engaged with the breakfast bowl.
Yes, please.
First of all, I want to say that
we are listening very carefully to each panelist.
Thank you, sir. Thank you. First of all, I would like to pick the subject wherever it is left by Jain Sahab. Justice is more important. Neither the appointment of judges are important, nor the incursion of government is so much important. The only thing important is the justice delivery system to the people. It is still affected. People are not happy. That is why the civil society is also speaking so many things against the judges and their appointments. One thing is very clear. The collegium system is not the creature of the constitution. This is very much clear. Collegium system is not the creature of the parliament. It has not come, this institution has not come from any act of the parliament. It has got birth from the judgments. From 1950 to 1973, there was no confrontation between the government and the judiciary. It was running through mutual consent. It has started with the elevation of Justice A.N. Ray, who has superseded the three senior most judges to the post of Chief Justice of India. And after that, there came the S.P. Gupta case, and thereafter came the SCRA versus Union of India, in which the concurrence was meant to concurrence of the Chief Justice and the Collegium. Before that, it was the concurrence of the President of India. Why the Collegium system is so much under fire? You have already read over the views of an IS officer that the appointment system is not fair, not transparent. opacity is there. This is raised by the President of the Vice President of India. This is raised by the Union Law Minister of India. The appointment system is suffering from nepotism. The appointment system is not taking the representation of all the peoples. The merits of young lawyers are suppressed. These are the points. Somebody is also saying that it is unconstitutional. Collegium is unconstitutional. It has not got any place in the Constitution. These are the things which has the superintendence of the high courts by the Supreme Court. It is nowhere written in the Constitution that the appointments of the high court judges, the Supreme Court will come into the picture. But the thing which I want to say here, but even after that, the independence of judiciary is the sine qua non for the survival of democracy. There is no gainsaying in saying that the appointment and selection of judges should be left with the persons who know the law, who are the judges. It is not the majoritarian government who can do it. Government is also not very much pious and sacrosanct in introducing the NJA system. NJA system is also unconstitutional because before NJAC, it was the concurrence or the consultation with the Chief Justice or the collegium system for appointment of the justices of the Supreme Court or the High Courts under the respective articles of the Constitution. And for the appointment of Chief Justice, it is the sitting Chief Justice who will name his successor. This is the process. Where there is written that the Parliament will take the role of appointing the judges, it is also unconstitutional. All of us know that in 80% of the cases, either the central government or the state governments are the party. When the central government is a party to the cases, how can it be under the appointment system? After all, the system of natural justice will be violated. No person can be the judge of his own cause. So judicial system, because our system of governance in our country is guided by or influenced by the system prevalent in the US. In USA, there is separation of power. Under Article 50, there is separation of power. Judiciary has to be kept away from the system of the executive and the legislation. But through NJAC, government has tried in 2014. NJAC is not in being now. It has been struck down in 2015. It is a dead law now. So it is the collegium system which is working. But when the NJAC was struck down, why the collegium system was not reformed? For what the people in civil society and for what the other peoples are crying. No reform was done, but rather it was continued in the previous form. There is no HR system in the collegium system. There is no date on which date the selection process will be made and how much time it will take. Total system is opaque. All the things are done in the closed room. Recently, one person has filed an RTI. Supreme Court has said that no, it is not available on the public domain. It is also said that collegium system is the law of the land. There is a tug of war. This is unfortunately on the part of the governance of India. But at any cost, if we go back to the Keshavanand Bharti judgment and Minerva Mills judgment, the power of judicial review, power to check the validity of the act, power to interpret the law rests with the judiciary and not with the legislation. It is only judiciary which can protect and save the people from the majoritarian tyranny of the Parliament. Because there is another system of governance in the Parliament, the persons with majority that comes there and make the legislations. But who will interpret? The framers of Constitution have made the judiciary as the guardian of law. Yes, we need reforms. Yes, we need modifications. But at any cost, any attempt to control the judiciary through the legislature shall act destructive and shall ruin the democracy of India. At any cost, the appointment of judicial system should not go to the legislatures. This is my view. Thanks. Thank you.
Thank you very much, Advocate Singh, for giving your views, and he is of supporting Collegium with some changes, but he says that it should not go to the legislature at any cost, otherwise it will be a very, very disaster for the country. Thank you very much. Paucity of time, so I will not take much time, and I would go to the next panelist guest, and he is Advocate Gagan Gandhi. Advocate Gagan Gandhi is the managing partner of Niti Nyaya Law Office in New Delhi. After doing his graduation in mathematics and statistics from St. Stephen's College, he completed his management from Faculty of Management Studies, FMS, University of Delhi. He worked in American Express Private Limited in their Risk and Information Department before he decided to do law from Faculty of Law, University of Delhi. Welcome, Advocate Gagan Gandhi, on our show. But before I will go to you, I have one more view from our viewer opinion. He is Mr. Duli Chand Karel. He is the national president of Bharatiya Swarnkar Sangh. And his view is it should be decided by a board consisting public forum, political forum, and judicial forum, and a yearly meeting be conducted to assess the functioning of judges. These are the view of Mr. Duli Chand Karel, the national president of Bharatiya Swarnkar Sangh. Advocate Gagan Gandhi, you have heard the views of our two Honorable Justice Mehrotra as well as Honorable Justice Saxena, as well as two prominent advocates, Advocate K.C. Jain and Advocate D.P. Singh. They have given their views. Now, we would like to know from you your views on this very, very important topic that which we are discussing today, and your views, because you are based in Delhi and you are dealing with the Delhi High Court as well as the Supreme Court on a daily basis. Other three, our advocates, two other advocates are not based in Delhi directly. But your views on NJC versus Collegium. Advocate Gagan Gandhi, please.
Thanks, Mr. Goel, for giving me an opportunity to share my views on such a sensitive and contemporary issue, and to share the dais with my learned co-panelists, whom I was actually hearing, and very, very robust views coming out from them. To start with, actually, what is happening is that we are questioning certain form of appointment of judges which has taken place, as my learned friend was talking about, through the 93 judgment. And then subsequently in 2014, NJAC came into being. Now, what was the history behind it? As Mr. Singh was pointing out, that it is not a creation of parliament, neither it is creation of constitution. But yes, it has evolved over the years, and it has stood the test of the times also. So if we look at three wings, which is legislature, executive, and judiciary, all of them, they have their own infirmities. But it does not mean that we start questioning their existence. Today, is not the executive plagued by biases? The answer is yes. Is not the legislature having biases? We see families after families. They are running the show. They're running the political parties. They're running the government. So why we not question that? We do not question it. Why? Because we do not see. We have accepted it. But when it comes to a collegium, we have not been able to accept it. I will come to why, actually. Now, when it comes to bringing RTI under, when it comes to bringing political parties under the ambit of RTI, there is a strict no. No, we do not want. We do not want to bring it. How the candidates are selected, how the funding is being done for political parties. We say no. And we have seen with greater difficulty this country witnessed the passing of the RTI Act, the journey of which started in 97. So transparency is always good for democracy, but to what extent? Now comes the question that whenever you have a strong executive, which the country has right now, there will always be a tug of war, as my friend was pointing out, between the judiciary and the executive. Now this question remained silent because this country did not witness the strong executive, because the country was passing through a coalition era and the executive itself was weak. So how will that executive question the appointment of judiciary? And there was a time when all the decision making, that space was actually taken by the judiciary, which was coined as judicial activism. Now, that is the beauty of the system which our forefathers actually formulated. Now, what is the beauty is, if any wing falls weak, there is no void created in the system. The system is itself able to take up, or it's able to fill the gap in the system. So are we not witnessing the political control of the executive? Now, do we question that, no, this is not the right system? We should have each minister being appointed by the democratic process. Why only the one a political head who is appointed is appointing other council of ministers? No, we can't do that. We can't be questioning every system which we have adopted and accepted it over the years. Yes, there can be infirmities. There can be infirmities has to be looked into. The question is that whether the decision-making process of the collegium, should it be made public? So these are the questions to be debated. As my friend was pointing out, today, if you see 50 to 60% cases, the government is the party, directly or indirectly. I may be underquoting it. It will reach to 70 to 80%. My learned judges friend will agree on that fact. Now see the situation when I am witnessing a dispute and I am being appointed by one of the parties who is party to the dispute. Now, how will I be independent to take decision? Because my appointment is being controlled by somebody else. Yes, when it comes to removal of judges, I see that we should be focusing on that aspect. Why the impeachment process is made in such a manner that it is difficult to even initiate it. So these are the questions. How we can improve, how we can bring transparency in the judiciary. If that is the question, that yes, I am for it. But yes, if you're saying no, the political head is going to have member in that appointment, then we are moving in a difficult direction. Because tomorrow, because this country has already seen 497 being struck down, 66A struck down, 377 being made legal. So these could not have been possible. These could be made possible only because of this fact, only because of the fact that yes, I had an independent thinking structure.
Right.
Nobody is
right to privacy as well.
Yeah, put to Swami judgment.
Yeah.
So nobody is sitting on my head. So until and unless somebody is sitting on my head, I will not be breathing freely to share or to evaluate it objectively. Now, these are some of the things. Indira Gandhi versus Raj Narayan gave the way for it. Now, can anyone imagine an election of a prime minister being declared null and void? Answer is no. So today, that is the level of evaluation which the judiciary has to do. So it is not an easy task actually. So if on the top of it, we have one more variable attached to it, now see the plight of it, what is going to happen. As the other co-panelists were talking about, the pendency of cases, the recruitment of judges, the transparent decision-making process. Yes, definitely. These are the reforms which is pending, and no system is perfect system. Now, when it comes to the bringing society, which we see it as, which is merit-based. Now, why we are questioning it is that there is nepotism. Judges are appointing their family members, and subsequently this show is running like it. So we have to answer that how we can correct that. The answer is constant evaluation. And the judiciary people are going to judiciary not because of choice. Let's not be under that mistaken belief. They are going it because of the compulsion. And why compulsion? Because of the apathy or the indifference of the executive. That is what is making them land before the judiciary. And judiciary happens to be the last resort. Because after that, there is no other where I can plead my case. So hence, it becomes easy also to target that wing. Because that's the last resort, because after that, there is no resort left. So by targeting that, are we doing justice in itself? The answer is no. Because I myself am questioning that before whom I am representing is actually plagued by a bias. So how can I expect a favorable outcome or an objective outcome for my client? Because I myself is under that belief that the person whom I am representing before is already plagued by some nepotism, some psychophancy or something other. But let me tell you, political class is even here. You still have certain evaluation criteria. There, what is the evaluation criteria which you're talking about? That if you have been close to somebody, if you have been able to manage the elections, if you have been able to influence the electorate. So are these not infirmities in that system? But are we saying that no, we should actually change the entire political system? No, that is not the way out. So similarly, like Supreme Court, actually the office of CGI recently was brought under the ambit of RT. So these are the changes. These are taking place, but we cannot expect it overnight. So they are actually bringing it under the domain of public, so that public can see, evaluate, and judge that how we are actually, we had the assets and liabilities of judges being made public. What is the purpose of doing that? So that people can know that when the judge was appointed, he was having so many assets. When he is retiring, he is having so many assets. So these are the ways to bring transparency. Just pinpointing at one thing that this appointment is problematic is not going to solve the issue. On the contrary, it is going to further increase the problem, because the same many judges will actually not be free. So our CJI recently, why this system gets clogged in the High Court and Supreme Courts? Because the lower judiciary fears granting bail. The lower judiciary fears granting stay. Now, if you remove that fear element, see, this clogging of the system will get away. So it is everywhere. So if executive is having a fear of a political transfer, obviously you will not take decision. And what will happen? Ultimately, you will land up before the judiciary. Now, what executive will think that let the judiciary decide. Why should I get into it? Let me enjoy my career. So fear element has to, for any decision to be taken by anybody, the fear has to go away. But yes, this present system with checks and balances is the robust system. Yes, as the co-panelists talked about, we need to revisit, we need to reform the existing system.
Thank you very much, Advocate Gandhi, for giving your views. And he also says this is a robust system, that is a collegium system. Only we require some revisit to it and reform it. Thank you very much. Now, my questions, it's a difficult thing to ask the question to the justice sitting here. But first, my question to Honorable Justice Mr. Rajiv Lochan Mehrotra. We have seen in India the fate of election commission. Recently, CGI or someone of the judge, I can't quote right now, but someone has mentioned that we require like session election commission. And today, it clearly shows that the present election commissioners or the chief election commissioner are spineless, or they don't have the same guts what Mr. Session used to be. We have seen the CBI in Parrot and whatnot. If it will be under the direct control of the legislature, don't you think the Supreme Court will also be a parrot of the government, or it will be like the spineless election commissioner? What you say about this, Honorable Justice Mr. Rajiv Lochan Mehrotra?
जैसा कि अभी हमारे बाकी पैनलिस्ट ने कहा, ये सच है कि बहुत सी चीजों पे मैं बिल्कुल सहमत हूं कि जुडिशरी की इंडिपेंडेंस बनी रहनी चाहिए, क्योंकि कॉन्स्टिट्यूशन का बेसिक स्ट्रक्चर चेंज नहीं किया जा सकता। लेकिन वहीं पर चाहे वो चीफ इलेक्शन कमिश्नर हो, सीबीआई चीफ हो, सीबीआई चीफ के अपॉइंटमेंट में भी सुप्रीम कोर्ट जजेस, चीफ जस्टिस ऑफ इंडिया इन्वॉल्व होते हैं, अपोजिशन लीडर इन्वॉल्व होते हैं। इसलिए केवल ये कह देने से कि वो बायस्ड हैं शायद बेईमानी होगा, क्योंकि उनका अपॉइंटमेंट प्रोसेस ही इतना ट्रांसपेरेंट रखा गया है कि उसमें चीफ जस्टिस ऑफ इंडिया भी हैं, अपोजिशन लीडर भी हैं और प्राइम मिनिस्टर आर हिज नॉमिनी भी है। इलेक्शन कमीशन के बारे में अभी जरूर कुछ कहा गया, लेकिन इलेक्शन कमीशन, अब देखिए ये कहने को कि साहब कभी चीफ जस्टिस ऑफ इंडिया कोई बहुत स्ट्रांग आपने कह दिया या पीएम मोदी साहब बहुत स्ट्रांग प्राइम मिनिस्टर हुए, बाकी क्यों नहीं हुए, तो ये कंपैरिजन हमेशा मैन टू मैन डिफरेंट होता है। प्राइम मिनिस्टर बहुत स्ट्रांग है तो बहुत अच्छा रूल कर रहे हैं, प्राइम मिनिस्टर बहुत वीक होंगे तो रूल अच्छा नहीं होगा। एग्जैक्टली यही देखिए चीफ इलेक्शन कमीशनर है, इलेक्शन कमीशन के बारे में भी है। हर आदमी टी शेषन नहीं हो सकता, हर आदमी नरेंद्र मोदी जी नहीं हो सकते हैं, हर आदमी सीएम योगी नहीं हो सकते हैं, हर आदमी I should not say always Justice D.Y. Chanchud नहीं हो सकते हैं। So there should always be comparison in between the, और still I think कि हर चीज चैलेंज हो सकती है बिफोर द कोर्ट, इसलिए इंटीग्रिटी पे किसी के उस पे शक करना should not be proper.
Okay. Thank you very much, Honorable Justice Mr. Rajiv Lochan Mehrotra. Now my question goes to Honorable Justice Mr. Sudhir Saxena. When we talk about the elevation, why not there should be an examination where all the judges, if you want to elevate even the High Court just to Supreme Court, why not they appear for an examination decided by definitely by the Supreme Court judges, set up the paper or viva or whatsoever. Why not we do that and then elevate instead of elevating by choosing themselves? Although I know there is some procedure that you have to see the judgments, what they have given and what not. But why not we have an examination so that people, the perception of the people should be changed, that no, it is a properly elevated. There is no bhai bhatija war. What you say about this, Honorable Justice Saxena? Please unmute. Please unmute.
Before answering the question, I'll refer to the remark about Session. Session could become Session because of the interference done by Supreme Court headed by M.L. Venkatacharya. He was also like other election commissioners sitting at the table of Joint Secretary Law. And you also said that about CBI and other systems. Supreme Court did make some effort under the J.S. Verma's tenure to take it under control, but it was foiled by the executive. That's a different matter. Now you say about examination for the elevation. There is a system of blending. Some are direct put, some come through examination. Now lawyers, some lawyers are specialists in labor law, like Mr. D.P. Singh. Some are experts in criminal law. Some are in taxation law. Therefore, there cannot be any uniform examination. Moreover, lawyers appear in exam every day. They appear before court. Once they don't get stay order or bail order, their entire source is closed. So they appear in examination. Their consistency in practice, that is examined every day by the courts, and then they decide this is meant to be picked up and considered. Therefore, examination for entire is not possible, and for higher positions, this is not done also. Blending is good. I say you are right. It should be, if it is 50%, then of course the blending will come. And we can do by transferring the judges from one high court to other high courts in the initial level. That will also be able to check this malady which we are pointing out. Thank you, Mr. Goel.
Thank you. Thank you very much, Honorable Justice Mr. Sudhir Saxena, for giving your answer. Now my question goes to Advocate K.C. Jain. Advocate K.C. Jain, it is coming about the transparency. There is a thing that case has been filed to show what has happened during the meeting of Collegium. If it is, then it means that all the cabinet meetings of the central government or even the state government should also come under the same scrutiny of the public, that why this decision was taken, who has taken, what has been expressed by the minister or not. Is it correct, or this should not be come to the public domain for the that why that so and so has been elevated or selected?
I think there should be some information, but not the complete information, because in case a person is considered and he is rejected for some reason, and if those reasons are brought in public domain, then it may not give a good message for the future candidates, because they will see that their image would be tarnished in case they don't their candidature is not finally accepted. Therefore, in order to protect their dignity and also not to stop the future persons coming in that fray of becoming a judge, I think the entire communication, entire discussion in the collegium should not be brought in public domain. Thank you.
Thank you very much, Advocate Jain. Now my question goes to Advocate DP Singh. Advocate DP Singh, recently someone has made a comment that you cannot dictate the president, you cannot fix up the time bar to the president of India. The Supreme Court cannot, because for that once they have sent that time, president can take it, so her or his speech time for 4 months or 1 year or 2 years to sit on the reports. Do you think it is correct when everything is done by time bar, right from the bottom to top? Why there is no time bar that once the recommendation has gone, it should be approved in so much time? Otherwise, it should be by default, by deemed, it should be approved. Do you think it should, then the appointment will be faster and the decisions be taken faster in this collegium system?
To me, these are all the gimmicks to influence the judiciary to come to their terms. In every work, in every action, there should be a time bar. It should not be unlimited. And it has also come under the comment of the Supreme Court judgment that this is why most of the seniors and renowned advocates don't want to be named as the prospective judges of the courts, because they feel that their name will be given and it will be left for years to be considered. So this is also a bit derogatory for the advocates who are going to be advocates, or the persons who are going to be elevated from the subordinate judiciary.
Okay, thank you very much. Now my last question goes to Advocate Gagan Gandhi. We talk about nepotism. Now we know everywhere in India or all over the world, doctor's son prefer to become doctor because he is seeing the atmosphere as a doctor. And he's, if a doctor is a cardiologist, the son likely to become cardiologist, similarly gynecologist. We have seen it. We have even seen the actors, Bollywood actors or anywhere actors, their sons or daughters are also entering the same field. Even advocates, we have seen the advocate firms, generations, 5th generation, 6th generations, they are practicing. Then if a judge, a capable judge, if his son or a daughter or whosoever becomes the judge, why we are crying? Even in the politics, earlier they used to give a name of a one political party. Now I can name all the political parties, yes, except those who are either not married or they have left their wife. That is a separate thing. Otherwise, almost whosoever is having their sons or daughters, they are all in politics. Why the nepotism only for judges, Advocate Gandhi?
No, it is not. Actually, we have to look it from the other point of view, which is the accessibility. Now, why actually doctor's sons become doctor is because of the accessibility, because of the ecosystem which he witnesses day in and day out. So now, if he becomes doctor just because his father is a doctor, that is questionable. If he becomes a judge just because his father or mother is a judge, then that is questionable. The question is not the other way around, that the son of a judge is becoming a judge. The question is actually other way, whether he is becoming judge just because his father is a judge. That is the question to be asked. Now, the second thing which you have pointed out is nepotism. So we see that there is a concept of senior advocate designation. So in the recent case of Indra Jaising, we have actually quantified it. So the judiciary is making self-corrections. So it is not that judiciary is oblivious to the systems which have been adopted and accepted since the independence. So recently, there was a question raised on the advocate on records also, that this system is alien to the concept of or right to practice. Now, these systems have evolved and there is an objective. So we cannot get disconnected to the objective. Okay. Now, in quest of equality, if we start making people who are not actually delivering to the people who are delivering, then we will face a different kind of situation. So the person who is coming first in the class, if he is coming first just because he knows the class teacher, then that's questionable. But it does not mean that we will not rank the person who is capable.
Thank you very much, Advocate Gandhi. But I am sure that our CGI is not a. He has proved that he is worth and he is delivering very good judgments. People are praising also. Anyway, thank you very much. So, viewers, we have seen today the legal luminaries have given their views on a very sensitive, controversial, hot topic, and they have. This is very clear. Yes, we must understand one thing, that none of the system is a foolproof. But whatsoever system is going on, one has to revisit, one has to see to it that it can be improved. But to discard it and to give under the control of the government, then it will be a disaster, because everybody knows that the government is a party in maximum number of cases. That's one of the panelists says 70 to 80%. Then what is going to happen? And in that also, if a particular political party will be having the say in the judiciary, then what is going to happen? One of the panelists says that there was the judiciary who has invalidated the election of Mrs. Indira Gandhi, the one of the most powerful Prime Minister of India. So, but today the situation is changed. If we will again do the same thing, and the legislator will start interfering every day, and the statements which are coming from a very honorable post like a vice president or the minister of law, it is also unfortunate, because then the common man also feel that the judiciary is nothing. Otherwise, if they can speak, why not we can speak? So we have to keep a decorum. After all, they are the custodian of our law as well as the democracy. Although legislators also have a very important role, but not to degrade the judiciary just because they are not giving the orders in their favor. Thank you very much. And today's program has been telecasted by V4 News, Karu News, V4 Stream, Malandu TV India, News Now se Samvad Sarocar News, Bharat Post News, Gyan, as well as shown live on Facebook and YouTube. And thank you very much, Honorable Justice Mr. Rajiv Lochan Mehrotra. Thank you very much, Honorable Justice Mr. Sudhir Saxena. Thank you very much, Advocate K.C. Jain. Thank you very much, Advocate D.P. Singh. And thank you very much, Advocate Gagan Gandhi, for giving your very free, frank views, legal views and opinions which are legally sustainable. And thank you all the viewers who have sent the opinions, might be from one side or the other side, but it makes no difference. After all, we are in democracy. You have full right to send your opinions, which we are going to read out without editing. But only my request is, try to send the opinion not more than 50 words, because sometimes it is very difficult for us because of the paucity of time. Our show is a limited time. But thank you very much, and keep sending more and more opinions. Thank you all the viewers for watching our show.